Malawi is called the warm heart of Africa. I wish I could say that's entirely true. We do have a very, very, what I may call, regrettable history of authoritarianism. You know, from independence in 1964 to about 1994, we had one president who basically banned all political opposition and went to the extent of creating a parallel court system because there was one particular decision that didn't go according to his expectations, and he went into parliament and told the MPs that if these lawyers who are trained in the bars of in London think that they can come here and acquit people on the basis of these so-called presumptions of innocence, they must recognize that we have a different attitude in Africa to justice, and will create a judicial system that will better serve our needs. So a whole parallel judicial system was created, and one of the first things they did in that system was there was no right of audience for lawyers. And then the bulk of the judicial work was actually assigned to that. And when I say the bulk of the judicial work, I mean everything, including treason, homicide, and anything else under the sun. So all the work was being handled by people who are not trained as lawyers, predominantly traditional leaders. And the rule of the whole process, if I may summarize it, was the assumption is there's no smoke without fire. So if you are accused, most likely you are guilty. But because of that long gap of very little legal profession, you didn't have enough lawyers in my country. When we now reverted back to a constitutional democracy that actually abolished these courts and required judges who are legally trained to man those courts. On a personal note, I was studying to become a medical doctor, so I did A-level sciences. I got straight A's in my A-levels, but as fate would have it, these doctors used to be trained abroad. So my only motivation for wanting to go into medicine was so that I get a ticket out of Malawi. The very year I was supposed to go into medical school was the first year that Malawi opened its own medical school. So this beautiful, so this amazing plan sort of got very distracted. I would have been happy to go there if not for somebody who was a close friend of my brother's who had his own brother come back from studying medicine in Sydney, Australia, coming back to complete his studies in Malawi. And in those very early days, the facilities were very poor, so they didn't have enough labs and so on. So he said, you know what, this is not medicine, they're cheating you. So I had to think of something else to do. And my brother, I'm the youngest of 3 boys and I've got 2 sisters, so my brothers could never be wrong, you understand? I mean, everything they tell you sort of carries a lot of weight. So he said, you know what, I think you can do law. So I went into law school, and I was very frustrated in a way. Because, you know, in science, 2 + 2 is always 4. I do essays, and I look at my friend's essay, and I'm looking and I'm saying to the professor, like, you know, how do you distinguish between me and his work? You know, it seems so arbitrary. So that created a lot of frustration. Ended up doing what young men do when they're frustrated, and did a lot of partying and stuff. Almost got removed out of university, and then I had a conversion. So I literally became a serious Christian, rediscovered my value and purpose in life, and I said, you know what, this law thing can actually work. And I began to become more alive to the transformation agenda that was going on in my country at that time, because that was literally just a year after Malawi became a democratic constitutional order again. I did some internship in law firms for my 4 years as a law student, and that experience actually decided for me that I could never work in a law firm. One of the things I didn't appreciate was the whole idea of just working to make money. Because of this gap I've spoken about earlier on, the legal market was so lucrative. You could literally leave your job in the morning and have a wonderful job by 2 in the afternoon, because everybody's looking for lawyers. The attitude therefore was, if you're a good lawyer, you go to the top law firms. If you aren't so good, you get some of the other law firms will pick you up. If you're just a lawyer, then you can go and work in government. And if that's even harder, then you go and sit on the bench. And I found that whole attitude to be so wrong. I said, look at me. I happen to come from a very ordinary family by Malawian standards even. And this is the government that has taught me all the way from primary school, university, and given me a degree. And all of a sudden, I become too good to work for them. I said, no, I think my people deserve to be served by the best. When I did my postgraduate studies in London, I had one of my lecturers was the vice president of the World Bank, a guy from Ghana, who took a liking to me, you know, from our interaction in class. He personally approached me and told me, you know, if you're prepared to come to Washington, there are internships available and we can see what we can do from that. And my answer to him was, I don't think you can afford to pay me. Now, he laughed, of course. He says, what do you mean? I know Malawi. I mean, I'm an African. You can't tell me that you can pay, you get more money in Malawi than you would in Washington. So I told him, you know, the joy I get, the gratification I get from saving my people can never be equated to any money you can give me. So for that reason alone, I'll pass. So he said, anyway, you're still a young man, get my card. If you change your mind, just give me a call. Well, I have lost his card. I haven't called him yet. So the whole emphasis there, why I'm saying all that, is not just to show off, but to say, yes, I'm a young judge, and there are a lot of stereotypings. There are a lot of issues. I love stereotypes. I love to defy stereotypes. I love people to be surprised by what we can do. You know, whether you like it or not, judicial work requires different skills to litigation. So you need judicial training to fill that gap. Even for those judges who are already experienced, there's always the evolving nature of disputes and content of legislation. You know, we're talking about issues of cybercrime and internet. You're talking about issues of the social media and its impact on you as a judicial officer. You know, those are real issues that were not even there even when I was growing up, and I'm not that old yet. But those issues are bound to generate legal disputes. You know, and we need training to be able to cope with those matters. You can't be a good judge if you're not willing to put in the time to think. You know, most of your work is done in your head. And the more you can train your mind to be active, as it were, and not just be passive, I think the better that you'll be at making sound judicial decisions. One of the reasons I personally gave myself a challenge of doing a PhD when a master's degree I think was adequate for my purposes, was I'd recognize that kind of attitude, that culture amongst judicial officers that didn't want to be taught by somebody who didn't understand their work. So I said, all right, if I have to get the right skills to be relevant to train others, I think I'll do that. And that's part of my motivation for what I did for my PhD, which was purely about judicial methodology and constitutionalism and democratization, because I think those are very foundational issues in a democracy like ours, which is still evolving. I felt like I'd been so privileged in my own little way, and privilege brings responsibility. Instead of just looking at how much more I could get for myself, I believe there's more to life than just money. And don't misunderstand me, I need a lot of money. But I believe you don't have to make that your sole pursuit of life. The judicial office, to me, creates a very, very rare opportunity. You tell me anything that happens under the sun that is not touched by the law. Anything. There is nothing that people do on earth that doesn't have a law attaching to it. And when the lawyers cannot resolve it for the parties, eventually they have to come to court. You know, you have this situation here, it's not a secret. You have Nkanda, I don't know how you pronounce it. But according to the commentaries, everything will have to end up in court at some stage. You know, it's a very indispensable part and parcel of creating a society that is functional. You know, we have research in our context, and I think it'd be the same in the South African context, but maybe not as pronounced. That has confirmed that the judicial process creates space for robust and open divergence of views. Actually, the very fact that you have two parties ordinarily, sometimes it may be more than that, but two parties advancing different points of view. You know, you may take it for granted because that's your bread and butter, that's what you do for a living. But again, if you think in my context, when you consider that for expressing a difference of opinion with the ruling powers, people lost their lives. So when you can create a forum where people can disagree without being disagreeable, you are moving forward. But you can also create an environment where people can articulate and remedy historical imbalances. Within the context of a judiciary, you can actually, the judiciary can create a model for society to say, you know, this is what change ought to look like. We cannot ignore our history, but at the same time, we cannot create more injustice as we're trying to correct our history. And that's very important in a democracy. But also, the whole point, which I think was very well made by Judge Nugent in the morning, that really the whole essence of being a judge is making a decision, but you must always make a decision that is justifiable. All right? So the whole concept of rationality, the whole concept of explaining why you want to do what you're proposing to do. I remember reading somewhere about your president, Nelson Mandela. There was a particular case where apparently he didn't need to go to court, but he insisted on going to court because he wanted to make the point that in the new South Africa, nobody is above the law. If you are in the new South Africa, whether you're citizen number 1 or citizen number whatever, even if your number doesn't even exist, you're subject to the same rules. You know? And that's important if you're going to create a fair society. There must be rules that are predetermined, and in the judiciary, we are in the forefront of enforcing that. Basically, I think there are two aspects to judgment writing. There's the mechanics of preparing a decision, and that's what I think we've heard a lot about. So you need to go through the evidence and settle the facts and go through your analysis of the law and so on. But I think something else that may not always be spoken of openly, but which is also critical, and I think Judge Nugent touched on it as well, the psychology of judging. You have to be untreatable. And by that I mean you must be open to persuasion. As a judge, you cannot approach a case with your own predetermined decisions. Having studied the law, having read the facts, what do I believe to be the right decision? And I must be willing to stand on my decision. I must be willing to risk even being misunderstood, as it were, by others. The dispute already involves at least 2 disputants. That's the minimum. So whichever way you're going to go, somebody isn't going to be happy. And then beyond the immediate litigants, there are other people behind you who are also looking at the same interests. So courage, I think, is a vital aspect of your armory as a good judicial officer. In my own anecdotal research, I found that some of the judges who struggle with judgment writing, actually they are struggling with making a decision. And because they are so indecisive, then they can't commit their decision to paper. There's nothing more stressful than having unconcluded judgments. Unless you have no conscience, of course, in which case you don't bother. But if you have a professional conscience at all, if you are not able to give judgments on time, it bothers you as a human being. So you need to be decisive. You need to be somebody who can look at issues, analyze the facts, and arrive at a decision. But you also have to have a lot of humility. The humility to want to listen to counsel when they want to make their point, and therefore you're going to be a courteous person. Recognize that you're working in a system where others may disagree with you, and live with it. I have colleagues who struggle with issues of appeal, like they feel they're better than the judges on the appeal court, and they feel like they should be the ones sitting on appeal, but it doesn't work like that. Now, the other aspect of the psychology of judging is your worldview. So you could have a case that is hanging in the balance and you don't know which way to lean, but I believe your own inherent values, your own philosophical inclinations, and there I must acknowledge, yes, it's an inclination, therefore it may be a prejudice, but it may have a bearing on which way you're going to go. I was reading an interesting article just as I was coming here on Thursday, research done in the UK, to the effect that the question that was raised was, are judges sensitive to economic conditions? According to her findings, and this data ranged from the UK, the US, and Europe, according to her findings, when the economic conditions were tough, and therefore the impact of a huge award for an employee who has been fired by a firm may actually result in closure of the firm and therefore more unemployment, judges would tend to award lower damages. But when the conditions economically were more thriving and positive, judges on the whole would tend to make bigger awards to the litigants. You know, as a trend, without the matters being argued in that fashion, meaning that the judges were considering factors just beyond the law and the documents in front of them and making judgments that they considered to be sensible within the context. I have heard a lot of criticism about the length of the judgments, for example, in the courts being too long, the constitutional courts being too long. But you have to ask yourself, why do you have a constitutional court in South Africa? Is the constitutional court intended to serve the same purpose as your courts of appeal? I tend to think not. And so when those people are authoring their judgments, obviously the methodology and the language and the elaboration that they may engage with will reflect different values because they are serving an agenda beyond ordinary adjudication. You can sit in a commercial court, which I had the privilege of doing when I first got appointed. You have a capitalist mentality that always promotes big business. You can have a more socialist mentality that is trying to advance the interests of the less advantaged of society. If you're sitting in a labor court, you may have a more unionist mentality. Or like I said about the constitutional court, you can have a more transformative, other than a conformist attitude to judging. And that has a bearing on how you do your adjudication. Like I told you, the courts were abused by the political elites in the past. So come our third multi-party elections, the government created a case whereby they were implicating the leader of opposition in parliament who was going to stand against the president, that he had forged the president's signature on certain documents that were circulated at Parliament House. So this guy was on trial. Interestingly, the state did not bring the president to court as a witness to authenticate the signature or disown it, but the defense indicated that they want the president to come to court. Now everybody was like, no. You know, very senior people at the bar and even in the court coming to me and say, you know, you can't do that, Chifundo. You're too young, your career is just starting out. You cannot summon the president. And my question was, what's the issue? The issue is the signature of the man. And by chance, the man happens to be a president. He is the best witness to this case. Let him come. So when I made the order, initially they wanted us to meet at State House, then they wanted us to meet at Capitol Hill. Then I told them, you know, we only have one premises for the courts. And thankfully, I had a very supportive Chief Justice. He called me and told me, young man, I am with you. Our courts meet on court premises. Don't bow. Of course, it wasn't easy. But the point I'm making is, I felt like it was a very good opportunity to make a statement about the value of the law. So when the president came to court, you know, at the end of cross-examination, the DPP stands up and says, Your Worship, you know, would like His Excellency to leave court first and then you can leave later. So I said, no, this is my court. The magistrate leaves the court, the witness leaves later. Why did I do that? I believe these are not just good notions. These are things I believe sincerely in. I believe the Constitution and the constitutional order can make a difference coming from a society that is used to hero worshipping its politicians and I said, no, we must do things differently. Funny enough, like I said, when you have courage, later on when things work well, you can look like you're clever. I'll not lie to you that it was an easy time. It was very awkward. I thought like I'd done something stupid and naive, but looking back, I don't think that I could change anything. But the point I'm making is your approach to your work is influenced sometimes by the things you believe are important. Let me just quickly say a few things about the responsibility of judging. Like I said, judgments affect lives, the economy, and the political world. And sound judgments promote constitutional legitimacy. You know, lawyers, we are fond of calling ourselves learned friends, and we can carry that too far. We actually get to a place where we think we're the most intelligent mortals. And we can make some arguments that are so far-fetched and unreasonable that an ordinary person cannot make. And I always like to think, as a judge, you have an obligation, especially in matters that have got great public interest, to do judgments that actually create a sense of, yeah, okay, things can go wrong, but we can trust our courts. And I can tell you that's what has happened to Malawi consistently. Just last year, in May, today is what? The 20th, yeah? Oh, the 30th. Yeah, last year around this time, we had elections. There were no results. We had elections, and there were like 10 days, no results. The matter went to court. And you know who caught the results? The judge of the High Court. And everybody was happy. You know, the fact that they believed that, no, our courts have been fair. Well, of course, allegations of corruption and so on are made, but the judge worked late into the night and gave a very reasoned judgment, and everybody was like, no. We know from experience, when matters go to court, they are decided on the evidence. There was huge tension in my country. There was serious tension because the elections were very close. You know, they were very close to call. But the issue that was being debated at that time was whether there was need to order a full recount and who could do that. The commissioner, the electoral commissioner, decided that that wasn't necessary. Other parties were trying to compel it, and the High Court came in and said, no, that's a call within the electoral commission. We have independent commissioners. Once you are dissatisfied with that, there is a process that you can engage with. So I just emphasizing again the significance of the work that judges do. And sometimes I also like to say, in my experience, I don't know about South Africa, in my experience, we have a lot of indigent litigants who can't afford counsel, and therefore whose cases will never make the news headlines. I've always felt like a judge, actually, you owe a greater duty of care to those nobodies, for want of a better term, than you do when you're handling cases that have got this glare of the public on you. If you make any mistake, everybody will be up in arms. It's more of an obligation when you're dealing with people who don't have the same kind of exposure, as it were, to publicity. You really have a duty to ensure that what you do is really fine work, because most of those people, if you mess up their case, they have no money to instruct counsel to appeal anyway, and you are the last port of call. So in closing, I will repeat what other people have said. You know, good judging demands much study. You can't hope to be a good judge by chance. And just because you did a good job yesterday doesn't mean you repeat it again in the next case. Every case that's coming before you, it's the same rigor of reading the papers and going into court and studying again and doing your research. And that process repeats itself over and over. Some cases are simple, some are complicated. Finally, on a personal note, I've found that your performance, in this case, you as acting judges, your performance could shut doors and open more doors for others. I know the dynamics and the politics that you're dealing with in this context, with the transformation agenda. Like I told you, I've told you my own story. There was a lot of stereotyping about young persons coming to the High Court bench. But thankfully, with God's grace, there's a few of us. I'm not on my own. I don't want to give that impression. But we had a Chief Justice a few years ago who believed in the younger generation. And he believed in giving people opportunity. And one of the things he was so insistent on is, I'm not going to promote anybody based on age alone. Seniority is important in our profession, but he says, when seniority creates a sense of entitlement, when people don't work hard and just expect that because I've been sitting here longer than you, I'm going to be ahead of you anyway, he said, I'm going to change that. I want people who can deliver results. I want people who can work and create an institution that justifies the resources that people are investing in it. And that's the opportunity we had. Thankfully, I hope our example has been a good example so that nobody will be prejudiced tomorrow because they will say, no, when you appoint younger judges, they are liable to misbehaving and so on. And my appeal to you is You may be in a similar situation. Maybe your particular group or category demographically now, you feel like are not fairly represented on the bench. If you get that opportunity, don't mess it up for others. Thank you for your attention.